pending a charge or trial, unless there are compelling reasons not to be so released. In the present instance, the prosecution has not proposed the release of the accused person on reasonable bail or bond terms, and concedes that there are no compelling reasons to continue holding the accused person in custody pending trial. There is also no contest that the accused person is a well-known public figure with a place of abode that is known to the authorities. The present conditions having been taken into account, the court is cognizant of the fact that the only condition that must bear on the court's mind in determining the question of bail and bond is whether the accused person will attend court if so released on bail pending trial. Having taken into account the nature of the offense that the accused person faces, and also having considered all the circumstances that have been presented before the court, this court makes the following orders. The accused person may be set at liberty upon securing a personal bond of 1 million shillings and one surety for security documents. The matter will be mentioned in the next 14 days. Let us have a mention for pre-trial.
Sure. Yeah, most of it, sure. Hey, let's have a mention. Hey,
Maintain order. Let us maintain order. Once we are done, then there are other things that let's have a date. 14 days. Now, unfortunately, the court is not sitting for the first 2 weeks of August. We will only be able to come back on the 19th of August.
Sorry? Please face the court. Now that the charges are not under the Terrorism Act, just requesting that the court considers administratively transferring this case to Milimani Court, which is more accessible to the parties. In the absence of that, or if it is necessary for the court to for us to make a formal application, we will be doing that.
Yes, I will advise that parties pursue that avenue if they so wish, but that will mean that we go as per the rules, and then the rules are clear on what to do. The cases will be transferred. So please pursue that avenue. I will put your sentiments on record in the direction of the parties to formally make that happen.
Additionally, and having agreed on the 19th of August as it is required, and the plans at the charge sheet, the only evidence that the prosecution will be relying, physical evidence, that is exhibits, are 3 tear gas canisters and a 7.651 mm ammunition. We confirm to you, Your Honor, that on Saturday, the 19th of this month, the DCI, led by one Mr. K. Roberts, Chief Inspector, ransacked, unlawfully ransacked the premises and the residence of Mr. Boniface Mwangi at Kenya without any valid search warrants. The search warrants, Your Honor, that they had procured, albeit our doubts, only dealt with the Mageuzi hub, where allegedly the subjects of the trials were allegedly recovered from. However, the illegal and the unlawful search at Boniface Mwangi's residence in Kenya ended up with the confiscation of his personal properties, some of them that are now or are supposed to be used by his children for their studies. That is one iPhone 16 Pro Max, a Samsung, mobile phone, one gray notebook, one black and white notebook, one black notebook, one MacBook Pro laptop, and one brown notebook. These are not ammunitions. Did not fall in this category of what the ODPP will be relying on in their trial. We urge that Mr. K. Robert be ordered by this court to immediately return those properties to the rightful and the lawful owner. And the court, as it considers our application, it will be alive with the facts. And I want to share the application with the court that they were seized, they were unlawfully seized by the said case in violation of the law. Number two, Your Honor, as I invite my last friends to rephrase the application, those properties are nowhere within the definition of ammunitions. They were unlawfully seized from the rightful owner. They are equipments that Mwangi's children, school-going children, are using. Number two, Your Honor, when Mr. Boniface Mwangi was arrested on the 19th, Mr. Keith Robert, who is present before court this afternoon, was quick to go to the DCI pages, that is the Facebook and the Twitter handle. And they initiated a broadcast that is disparaging, damaging, and defaming in the character of Mr. Mwangi, to the extent that the caption that Mr. Mwangi was to face terrorist charges. What we have this morning, and that's what Senior Hans is addressing you on, are not terrorist charges. On that other lip of my application, Your Honor, because the publication is criminally narrated these proceedings, noting that the equipment that were allegedly seized from Mageusi Hub are now subject of this trial, and they formed the reason upon which the publication was done, that Mr. Robert, Keith Robert, be ordered by this court to rectify that damaging, disparaging information contained on that handle. Because it has no relevance, yet it has serious implications as to the character of Boniface Mwangi. And the nexus between my application and the publication is that publication captioned the tear gases, canisters, and the alleged ammunition of 7.6 51 mm. So it has squarely lies within you, and it has some criminal association. And as such, Your Honor, you can order and direct that Mr. Robert does rectify that information. It has both local and international implications. I'm very sure Mr. Lempa will want to refresh that application.
Your Honor, yes. When the office of the Directorate of Criminal Justice puts your name as a criminal in a Twitter handle that is read widely, the subject of that particular Twitter handle is that he cannot even trouble anything because he's a terrorist. And that is the reason why we beseech you kindly let the DCI just correct that information. Article 35 is very clear that Mr. Boniface Mwangi has arrived on correction of any information that is incorrect about him. He is not a terrorist. He is a patriot. And therefore, any publication to the effect that he is a terrorist terrorism as an offense or a crime attracts international jurisdictions. And therefore, if the office of the Director of Criminal Investigations is not compelled, Mr. Mwangi can be arrested anywhere because he's a terrorist in quotes. So therefore, I don't think my good friends, Mr. Mashira, will have any opposition. Mashira will have any opposition on the correction of defamatory, incorrect, and malicious publication to the effect that the accused person is a terrorist. If they want to amend the charge sheet, they can. We are ready for them. Thank you very much.
You know, as I invite my then effect the deputy president permit me just to add a small point that if they feel that they are not in a capacity to address our application today, would be making an application for cross-examination of Keith Robert, so as to lay the basis upon which our application ought to be admitted. Number two, other than just deleting and rectifying, we also ask them